Happy Sunday, everybody. Good morning, good afternoon, good evening, wherever you are around the world. Welcome to Family and Finance. And today we have a very distinguished lawyer and barrister and solicitor with us who is going to teach us a lot. Okay, so I have my notebook handy. I have my pen ready to write a lot. And I know that we're in for a lot of learning. So Barrister Nduka Ahanonu, welcome, sir. And thank you so much for being here on a Sunday afternoon.
Thank you. It's my pleasure to be here.
God bless you. God bless you. So today you're going to talk to us about a very valuable topic. But before that, could you tell us a little bit about yourself?
All right. So thank you for the introduction. My name is Nduka Ahanonu, like you've heard, and I practice law in Edmonton, where my office is, Edmonton, Alberta, in Canada. And I've been a lawyer in Edmonton, in Alberta for 14 years now, and I practice in the areas of family, immigration, civil litigation, and wills and estates. So the topic that we are going to talk about today is one of the key areas of my practice. And I also practiced for a bit in Nigeria, where I did my first degree, by the way, before proceeding to the University of Alberta for my master's program. And upon finishing my master's, I enrolled as a member of the Alberta Law Society after completing my challenge exams and completing what used to be called the bar admission course and CPLED. So here I am. I've been taking on students that I mentor and that I teach for years, and I've had so many of them who are practicing lawyers in Alberta, and some of them practice in BC and Saskatchewan. So I'm glad to be here to talk about a topic that is dear to my heart and which I believe is important to the members of the community.
Awesome. God bless you. Before we go into the topic, I want everybody please sharing Barrister's website. So his company is Duke and Company, and the website you can go to dukelaw.ca. He is the principal partner. He's the founder of the company, and this is his handsome face here and the rest of the team. So yes, please reach out. Give him a call. The number is on there, and he has a big heart for the community, and he really wants to help us out. Thank you so much, Barrister, once again. God bless you.
Thank you.
All right, so today we're going to move into the topic, and I'm going to say, Barrister, I will say, take it away.
All right. Thank you very much, Dr. Joshua. So today, the topic for discussion is how to set up a trust and appoint trustees for minors and dependents. And for us to get into all of that, I think it's important for us to understand what a trust is. And after explaining what a trust is, I will explain the difference between a trust and a will. I will discuss the types of trusts, and I will talk about family trust. I will talk about duties, compensation, and powers of a trustee. And I will also talk to you about how a trust can be terminated or varied, depending on what you wish to do. So a trust is a creation of law, just like a corporation is a creation of law. And it is an arrangement that is a legal relationship that's created by somebody, and that person is called the settlor. And what happens is that this person, the settlor, transfers assets to someone else who is called a trustee. And this trustee becomes the legal owner of whatever that's handed over to him or her to hold in trust. However, the trustee, even though they are the legal owner of whatever they have in trust, they are not the beneficial owners. They are holding those things in trust for someone else who is the beneficial owner. So even though, like I said, the trustee is the legal owner, the trustee is not the beneficial owner. So when we talk about the duties of the trustee, you will understand what the difference is between a legal owner and a beneficial owner. So a trust is a legal tool. And the person who is creating the trust, the settlor, can use a trust to achieve different purposes. They can use the trust to plan their estates. They can use the trust to protect assets. You can use trust in commercial transactions to keep creditors away from certain assets. I'm not saying it's the right way to do it or the wrong way to do it, but you can use it in that regard. And you can also use it in family situations to make provisions for dependents, minors, or children who are not minors, but they are disabled, not able to provide for themselves. So I think it's important for you to remember this. When a trust is created, the trustee becomes the legal owner of the assets that are vested in them. But the benefits arising from the ownership of those assets are enjoyed by the beneficiaries. And these are the beneficial owners, not the trustee. If the trustee enjoys the benefits arising from the trust, we have a problem, except if the trustee is also a beneficiary. We'll get to that. So,
Barrister, I'm not sure how you want to take questions. I have a private question here. Do you want to take questions as we go, or do you want to finish presenting and then questions can
I
come?
can take questions as we go. That's fine.
Okay, so I have a question here that says, what happens when the trustee dies?
Okay, so the trust instrument, the agreement or a deed, we usually make provisions for an alternate trustee. So what if this trustee dies? What is going to happen? So it's one of the things that should be dealt with in the trust. And if the whole thing happens that there is no trustee anymore, then the beneficiaries can make a court application to determine whether or not there should be a court-appointed trustee or whether or not the whole thing can go into the public trusteeship, which is the government taking care of it. It all depends on the circumstances and what the beneficiaries, what the trust assets are and what the beneficiaries want. If there are no trustees to take care of the trust assets any longer. Okay,
Thanks.
I hope that answers that question. So a trust is different from a will because a will is a document that somebody has created, and this person usually creates the document when they are alive. And the intention of this document is to say how things can be done when the person is no longer here. So the will speaks after the death of the person who made it. And that person is called the testator. And a trust can speak after the death of the person if the will created a trust in it. A trust can also speak while everybody is alive, including the settlor, who is the maker, the creator of that trust. So the trust does not have to wait until somebody dies. But the will can create a trust, but the will has to wait. And even a trust created by the will we still have to wait until the person dies. So that is the major difference between a will and a trust. So the next thing that I would like to talk about is the types of trust, because now I have talked about the difference. So there are two fundamental, there are two types of trust. One is the testamentary trust, and the other one is the living trust. In law, it's called trust inter vivos, but living trust. So the testamentary trust is the type of trust that you create in your will by saying, when I pass on, this and that asset is going to be taken care of by this person for the benefit of that person. It's usually a situation where you have minor children, or you have dependent children, or you have children who are not minor, but who, for some reasons, you don't believe should get those assets right away. It could be that it's your wish to say that when you pass on and when your partner passes on, that your children cannot get these investments because you're concerned that they might not manage those investments properly, or that for some reasons that they might squander those investments. So you might say that the children cannot get those investments until they turn the age of 30. If they do not get to the age of 30, they cannot get those investments. So if that is your wish, you can then create a trust in your will. Automatically, your executor, who is the person who will take care of your will, is your trustee. But then you are creating this testamentary trust that will prevent the executor from distributing things upon your death, except in accordance with this arrangement, which is to say, these children cannot have this particular investment or that particular investment until they turn 30. Or it could be until they finish university, or until they get married, or until a sudden event occurs. So the trustee, who is somebody that you trust, will try to carry out their wishes in that regard by saying to the children, your parent, your dad, your mom gave this to you, but you're not getting it until this happens. So that is the testamentary trust. And the other one, living trust, is the one that's operative when the person is alive. The person may say, okay, this particular set of assets should be held in trust for this child. And the person is still alive. And the person moved these assets to the trust, and the trustee manages the trust, and the benefits of those assets will then go to the person who is supposed to be the beneficial owner, which is the beneficiary. So there are things that you must bear in mind when it comes to trust. One is that there must be a set law, which is the person creating the trust, and there must be an intention to create a trust. Although sometimes a trust may be created by operation of law, but the courts don't typically push that one. If somebody has tried to create a trust, you are expected to do the right thing to create it. And the third one is that there must be a trustee who will be the legal owner and who will take care of the assets, and then the trust must name the beneficiaries. If the beneficiary is going to be your estate, the trust must make it clear that upon your death, everything from this trust comes back to your estate. It's up to you. But there must be a set law, there must be an intention to create a trust, and there must be a trustee, and there must be a beneficiary, at least one. So it is important for you to know that if the intention to create a trust is not clear in the trust deed, the trust deed or agreement is the instrument, is the legal document that creates a trust. If it is not there, the intention is not clear, or if the document is not properly prepared, you might end up having a failed attempt to create a recognized trust. And that is not what you want. If you want to create a trust, you want a trust. You don't want a failed attempt to do so.